Good afternoon, ladies and gentlemen. Welcome back to the afternoon session and come back to the IPCC Symposium 2019. I'm today's MC Caillou. In the second plenary session, Police Power and Civil Rights, Striking a Balance in Current Social and Cultural Environment, our speaker will discuss the balance between exercising police power and respecting citizens' legitimate rights during daily policing and various public order events, and also how the technology advancement has created an impact on this area. May we now invite the moderator and speakers of this plenary session to proceed onto the stage. Let's give them a big hand, please. Our moderator is Professor Karen A. Jo Laidler, Director of Center for Criminology, the University of Hong Kong. Thank you. Also, our speaker, they are Professor Simon Yang, Associate Dean Research Faculty of Law, the University of Hong Kong. And also Mr. Kwok Yam Shu, Oscar, Deputy Commissioner of Police Management, Hong Kong Police Force. And also Professor Christopher Forsyth, Emeritus Sir David William Professor of Public Law, University of Cambridge. And also Cheng Tung, Visiting Professor of Law, the University of Hong Kong. Thank you for joining us today. Let me pass the time to Professor Laidler. Thank you.
Okay, I guess that's on. Welcome everyone. I hope you enjoyed the morning session and got some relief from the heat, and welcome back for this afternoon session. I think all the introductions, one of my jobs was to do the introductions, but she's already so eloquently done it that we can just start off by hearing what from our guest speakers here today. So would you like to go first, Professor Forsyth?
Well, good afternoon, ladies and gentlemen, and I'd like to begin by giving my thanks to the organizers for inviting me to this symposium. I'm not quite sure what I'm doing here, but I got an invitation very kindly from Robert Tung in Cambridge, and I always love to come to Hong Kong, so I thought, yes, I'll go to Hong Kong and attend the symposium. And I must say, so far it has been well worth the visit. And I'm delighted that I was invited. Thank you very much. That's who I am. A legal academic, now retired, of very little sorry, can't you hear me? I was just saying I was a legal academic, now retired, so very little consequence. But perhaps more important than my academic credentials is the fact that I was for many years an independent member of the Cambridgeshire Police Authority, now abolished. So I saw from the bottom up how some of these issues play out. As such, I ran the lay visitor scheme, which is something that has attracted some interest amongst people I've been discussing this with in the corridors of the symposium, so I'll spend a moment or two on it. The lay visitors are ordinary citizens appointed by the police authority who have the right to attend a police station at any time, on any day, without notice, and should be given admission to go and inspect the cells and speak to anybody who may be in the cells at the time. I think it's quite a remarkable scheme. It started in 1982 on a non-statutory basis and was put on a statutory basis with the Police Act of 2002. And it formalizes the fact that ordinary citizens, obviously appointed and vetted by the police authority, ordinary citizens can turn up at the police station at any time and simply go and look and see what happens. And they can speak to detainees, not about their cases, and they don't attend interviews, so they're unlike the observer scheme in Hong Kong. They don't attend interviews, but they simply talk to the detainees about the conditions of their detention. Most of the complaints that they get are about dinner. The food is not very good, but there are occasions upon which a more substantial defect is discovered, and then a report is made to the Lay Visitors Committee, and the Lay Visitors Committee calls the relevant police officer forward to explain what is going on. So that was the Lay Visitors scheme, and I thoroughly enjoyed running it and thought it did a public service. I also chaired appointment committees to appoint chief constables and assistant chief constables, which was quite an experience and, of course, a huge responsibility if you chose a dud. And the people of Cambridge have suffered with bad policing, so it was very important to get the right person. And if you chair the committee to appoint a chief constable, then you have to chair a disciplinary committee to discipline a chief constable, which was much more difficult in my experience. And I, in fact, suffered the ignominy of being directed by the UK's IPCC to bring disciplinary proceedings against a particular assistant chief constable. It was a case about a lost file, and he was responsible for the loss. Now, a file can be lost, and that means that it's actually stolen and secreted somewhere or destroyed in order that a particular case cannot proceed against someone else or to do the destruction of evidence. Or a file may just be lost through negligence. And we were convinced on the police authority and on the discipline committee that this was just negligence, whereas the IPCC thought that there was something more sinister about it. And so they just directed me to bring disciplinary proceedings against a chief constable, and so I had to suffer that ignominy. We brought the proceedings. The chief constable was given, the assistant chief constable was given words of advice, and it came to an end. But that was some of my experience and in civilian involvement in the police. All this has led me to the firm belief that systems of police accountability that incorporate substantial independent elements are best placed to build public's trust and confidence. If people in whom the public already trust confirm that a particular police behaviour was not untoward, then that will be accepted by the public in general, one hopes. And if people whom the public already trust confirm that particular police behaviour fell below the standard required, then that will be accepted by the police. I'm afraid something's going wrong with this machine. How can I go back to where I was in the presentation? I'd like to go backwards. Yes, that's fine. The position of the police in Hong Kong is unenviable, it seems to me, at the moment. They are caught up in the growing public frustration over the stalemate in constitutional developments promised in the Basic Law and the Joint Declaration. This has led to real threats to public order, and of course some force, obviously minimum force, has to be used by the police. And as a general rule, the use of force is corrosive of the public trust in the police. At one point is clear, public trust will be destroyed if the police act in an arbitrary or abusive manner. What this means in the first instance is that the exercise of police powers must be subject to the rule of law. But what is meant by that? Here is Chief Justice Ma, the current Chief Justice of Hong Kong, speaking at the conference in Singapore, with his working definition of the rule of law, encompassing two connected facets. For me, the rule of law presupposes first the existence of laws that respect the dignity, rights, including economic rights and liberties of the individual. And second, the existence of an institution, we here of course mean the independent judiciary, to enforce these rights and liberties. The references to dignity and liberty in the context of rights are important. They undermine the point that laws must themselves be just and respect what we term human rights. The importance of the rule of law in promoting development as Chief Justice Ma. So here's two facets, two connected facets. The one, quite a formal requirement to respect the dignity, rights, including economic rights and liberties of the individual, and secondly, a rather wider idea that includes human rights. And human rights under the Basic Law, I'm leaving to Simon Young, Professor Simon Young, to deal with. I'll stick to the common law for the time being. As Chief Justice Ma's dictum shows, the concept of the rule of law forms a valuable part of Hong Kong's legal heritage. Significantly, he sees the principle of the rule of law as being relatively substantive, particularly with that in protection of human rights. And this more substantive view of the rule of law is sometimes called the principle of legality. More traditional, formal views of the rule of law are said to be thin rather than fat. And theories of the rule of law may be ranked from thin to fat, depending on how substantive rather than formal they are. Here is a statement of a thin theory of the rule of law. It's the great constitutional scholar Albert Dicey's view. The rule of law means, in the first place, the absolute supremacy of predominance of regular law as opposed to the influence of arbitrary power, and excludes the existence of arbitrariness or prerogative, or even of wide discretionary authority on the part of the government. It means, again, in the second place, equality before the law, or the equal subjection of all classes to the ordinary law of the land administered by the ordinary courts. And lastly, that in short, the principles of private law have thus been, by the action of the courts and Parliament, so extended to determine the position of the Crown and of its servants. Thus the Constitution is the result of the ordinary law of the land. Needn't worry too much about that third meaning for the time being. The fact is that there are starkly contrasting concepts of the rule of law, and this is irksome. But this is a reflection of the fact that the rule of law is not a law, but is a cultural phenomenon. The rule of law is not to be secured by passing a law and enacting a constitution such as the Basic Law. It's something that lives in the hearts and minds of the people. And that's what makes it work. Let's look at a fundamental example by viewing the general power of arrest of the police in Hong Kong. I hope the policeman on the panel will not be too excited and want to come and arrest me for this account. The general power of arrest is to be found in section 50 of the Police Force Ordinance, and there it is. It shall be lawful for any police officer to apprehend any person whom he reasonably suspects will be charged with, or whom he reasonably suspects of being guilty of. And I'll read only any offence for which the sentence is fixed by law, or for which a person may, on first conviction of that offence, be sentenced to imprisonment. That's the basic power of arrest that police constables in Hong Kong have. It shall be lawful for any police officer to apprehend any person whom he reasonably believes will be charged with, or whom he reasonably suspects to be guilty of any offence which the sentence is fixed for. That clearly envisages a bounded discretion whether to arrest. There's certain requirements that have to be fulfilled, reasonable suspicion being the most obvious one, and then the nature of the offence that they have to be reasonably suspected of doing. But it's a bounded discretion. There was an area within which the officer has a discretion whether to arrest. It must be stressed that the officer is not free to arrest anyone within those boundaries. The essence of the rule of law is that a police officer does not have an unfettered discretion to arrest anyone within the statute. The officer has a choice, and the question is, how is that choice to be made? And here one brings in the principles of judicial review, classic principles of judicial review. This is an eminent English judge, Lord Diplock, speaking in a 1984 case in the House of Lords, where he says, judicial review is developed to the stage today that without reiterating any analysis of the steps by which the development can come about, one can conveniently classify under three heads the grounds upon which administrative action is subject to control by judicial review. The first ground I would call illegality, the second irrationality, and the third procedural impropriety. This is not to say that further development on a case-by-case basis will take place. These words have become canonical to some of the principles of judicial review, and these are the principles that will determine how police powers may be lawfully exercised. The illegality concerns simply determining whether the arrest is within the statute, but in addition, the discretion must be rational and procedurally fair. Thus far, we've been dealing with the accountability of the police to the law, but they are also accountable to the public for the exercise of their discretion within that area that I've called the bounded discretion. Many devices to establish accountability to the public, lay visitor schemes, as I've suggested, investigation of complaints, independent investigation of complaints, systems of independent observers, all building confidence and trust. Thank you very much.
Thank you, Ed, right on time. Our next speaker, according to the schedule here, is Mr. Osterkrock, Deputy Commissioner of Police, in charge of the management section.
Thank you, Professor Laidler. As a police officer and formerly a detective, I'm naturally a suspicious person. And the fact that I'm given not the first opportunity to speak, okay, made me think that I may be finding myself in a position as the accused, okay, having the charge read to me first, and me having to answer to it. So just for the avoidance of doubt, I plead not guilty.
But actually, you're actually sandwiched between two lawyers.
Well, I'm the only one who will go to heaven then. Well, some might expect that as a police officer, I'm going to be speaking in defense of the police force here. I propose to do none of that. My job here today, I think, is to invite our audience to take a step back and look at the real issues here, okay, the bigger picture. Because there is a purpose why there is a police force in every society. We are here to deal with the ugly and the naughty and the nasty. We do not exist in a vacuum, okay, so that we can have a game between the cops and the robbers and people who oversee the police's work, okay? So I propose to just provide you a different perspective so that we can have a more complete look at the issues at hand. The topic of this panel discussion today, okay, presupposes that police powers and civil rights are diametrically opposed to each other, hence the issue of having to strike a balance between the two. It implies that if one side has more, the other side has or has to have less. But is that really the case? Is this how the dynamics work? Is this even the right question to ask in this context? Let us think about this. If there were no police, or the police did not exercise any powers, can an individual then enjoy his civil rights to the fullest? Is it even a good idea? What kind of society would that be if every single individual is free to exercise any rights to his heart's content? Wouldn't that inevitably bring individuals immediately into direct conflict with each other? Clearly, societies cannot exist in this manner. Some rights are therefore qualified. So in qualified rights, isn't the question about balancing the rights of the individuals against those of the others? Where should that line be drawn, if a line needs to be drawn? Who is there to determine that line? Who is the umpire or referee to enforce the respect for that line? Or more importantly, what is at stake here? Is there a bigger picture? If there is a bigger picture, then perhaps discussion at a forum such as the one we're having here has a critical role to bring out that bigger picture. But in this day and age, where extreme characterization of issues are so common and biases so ingrained, that task would not be straightforward. But we can certainly help this rational discussion by starting with an open mind and by going back to the basics. A simple example to illustrate. Individuals existing on their own can do anything they like, just like this little girl here playing with her toys. A really adorable, cute little girl. They don't affect anyone else when they choose to exercise their freedom. Freedom can be total within a physical environment. There are no constraints because none is necessary. Until there is more than one person. Very quickly, the actions of one person can affect the others to their detriment, or at least to their perceived detriment. And suddenly, that cute little girl is not so cute. Do we allow children to do whatever they want? We don't. We impose constraints, and we enforce them, often to the vehement objection of our children. Every parent would tell you that the constraints are applied and enforced in the best interest of the child. Every child would tell you none of the constraints are welcome. Despite these differences, we as a society, we accept the constraints are necessary and they need to be enforced despite the objection. We might therefore call these enabling constraints. The fact of the matter is, enabling constraints enable society to function. So there is naturally the question of whose job it is then to enforce these enabling constraints, or be the referee. Just as you must rely on football referee rather than the football authority FIFA to run a football match, it is the police, not the courts, who has to play the umpire at the time of the incident. Not because we have vested interest in the outcome, but because we are the proxy for those whose interest we seek to safeguard. That is, the others in the society. It is worth pointing out that the rules are not written for the benefits of the referee. The rules are the enabling constraints that describe the limits of the game so that no one can manipulate the outcome, though often it might be in people's nature to do so. Without the rules, there can be no game, and without enabling constraints in a community, you may not even have a functioning community. Let's think of more primitive times and an individual's place in a society or community or a village. Humans have evolved over millennia, as a cooperative species. There is evidence of cooperation from 90,000 years ago, when villages in early Africa cooperated to hunt large animals. Social cohesion, therefore, was a social construct, not a legal one. Village elders would have had the final say in what was healthy and not healthy, useful and not useful, constructive and destructive. So the concept of social cohesion and deferring to the authority of someone, village elders, a village council, what we can call the social rules of the game, has been around for tens of thousands of years in human society, not just a century or two. It is important in our discussion, therefore, to remember that these social rules of the game, they represent the fundamental fabrics of human society. Whether you like it or not, a functioning society is defined first by how well people coexist as a collective before they are assessed how extensively one can assert anyone's individualism. Still, today we talk about civil rights as being enshrined in law. There are very good reasons for that. Now, there are more learned people than me here, but it seems, at least in the West, okay, you can trace the issue of individual rights in law, as opposed to the state, to the 18th century, which includes both an American and a French Revolution. Of course, we could go back another 500 years, okay, to Magna Carta. But it was not until after the Second World War, in 1948, we had the Universal Declaration of Human Rights. The catalyst for this development was clearly the atrocities that were perpetrated in the years leading up to and during the war, as this picture is showing you. I point this out not just to state the origin of the Declaration, but to remind us the extreme nature of atrocities that these safeguards were originally designed for. Let us not forget, when we talk about human rights, although we often refer to the individual as the object, it is individuals as a collective entity that we seek to protect vis-à-vis ruling authority. So when people try to equate a single person's right, say, to occupy a public space to mount a protest, with the plight of the oppressed victims of the Second World War, that is what I meant by extreme characterization. Unfortunately, such extreme characterizations have basically defined the Hong Kong scene. Many disagreements about how rights are exercised often end up in courts, which ultimately have to decide what is lawful, whose rights supersede the rights of the others. But as the lawyers and judges, okay, in our audience know, okay, this is a process fraught with problems. Decisions can come months or even years after the incident. And in this digital age of social media and instant outrage, the complexities of any legal decision and the very particular context in which they are made, okay, are often lost in the noise. More importantly, court decisions tend to produce winners and losers. And this can be weaponized in ways that completely ignore the real basis for decisions. Also, long before any case ever gets to court, because police are playing the role of the referee, protesters often direct their anger and sense of outrage against the police officers on the streets. So this has become the prevailing narrative. Even the title of this plenary session has fallen into that trap, in my opinion. Police powers versus civil rights, striking a balance. Now look at the practical manifestations of these rights. Very close to home, individuals and groups harassing other people and groups, hounding people, kicking the backs. Is this freedom of expression we seek to preserve? In which society do you ever find such rights enshrined in law? If not, should anyone step in to stop this? Now, these are questions most people have not had to answer, because most people do not have to worry about having to intervene on behalf of those who are harassed, because you expect the police would do it. All too often in Hong Kong, freedom of expression is expressed as hate and anger. This is simply a fact of life, a reality in our society that cannot and should not be ignored in the academic discussion of rights in the comfort of an air-conditioned hall. Precisely the manner of expression is, because it is beyond reasonable, the police have no choice but to step in as the referee, and people then turn their anger onto the police. Now, do you see how inevitable this sequence of events is? How, as a society, we are vulnerable to manipulation by those who are bent on constructing a narrative of oppression by the authority. If you are a subscriber to that kind of narratives, I ask you to look at this picture and see if you can tell me that you truly believe the person wearing the mask there is the oppressed. How about this one? Know this, okay? Whenever the narrative is framed as them and us, this is manipulation. While police act as a proxy for the others to try to balance the rights of different sectors, who in civil society will exercise his responsibility to maintain community? I mentioned social media and manipulation. Now, there is an argument to be made that human behavior these days is being shaped by narratives, not the substantive facts or context, certainly not truth itself. The point is that manipulation is a very real phenomenon, and we are all vulnerable to it because of the nature of the internet and the anonymity it offers. In any discussion of police powers and civil rights and building safeguards around them, the community must be alive to this reality of the manipulation. This reality means that we are living in an age where facts and context are more important than ever, but less likely than ever to be effectively communicated. Because people these days hear what they want to hear and don't hear what they don't want to hear. That's simply the sad fact. But whatever narrative you adopt, it should not be difficult to understand the nature of constraints on individual rights and the very simple reason why they are necessary. There are many, many examples of enabling constraints on people's behavior that are rarely questioned. The prohibition on littering, trespass, theft, damage to property, public nuisance, because simply we have to live together as human beings. The only difference is that these other constraints that we take for granted are rarely exploited by anyone to construct political narratives, because they are incapable of evoking very strong emotions based on ideological positions. The point is that in any discussion of civil rights, participants must be acutely aware of the trap of emotional manipulation, otherwise rationality will be almost impossible, because there is only a fine line between conviction in one's belief and bigotry. Bigotry being the biggest enemy of rational discussion. So if you accept that there needs to be a balance that is struck between the rights of the individual and the rights of the others, then let's not forget that balance necessarily means compromise. And any bigoted position, whatever it may be, has no place in compromise. I mentioned at the start, is there a bigger picture? I believe that community is that bigger picture. And I have to emphasize, a functioning community is that bigger picture. The law serves the community, and we, police officers, we enforce the law in the role of the referee. Earlier, our speaker this morning referred to this principle by Robert Peel. He invited you to actually look at the part where it says, okay, the public are the police are the public. I would invite you to look at the second part of that seventh principle of the appeals principle. Duties which are incumbent on every citizen in the interest of community welfare and existence. Everyone has a duty to act in the interest of community welfare. One of Hong Kong Police's new strategic directions, is policing with the community. These are not mere words, but a recognition that it is for you, not us, to decide what kind of society you want, what protections you want or not, what protections you want to give the vulnerable or not. You decide the rules of the game, but then you have to be responsible for the consequences. So I'll return to the title of this session, Police Powers and Civil Rights, Striking a Balance in Current Social and Cultural Environment. Should it not be civil rights and other people's rights? Striking a balance? The need for balance can and should come from members of the community, just like you. You could add some much needed perspective, or you can add more outrage and fuel for people who are very willing not to be peaceful. Balance is and has to be a social construct, an intrinsically restraining influence on excessive behavior, destructive behavior, reinforced by the law, not replaced by the law. I welcome your thoughts. Thank you.
Thank you, Oscar. Okay, Simon.
As a member of the Faculty of Law, I welcome you to the building, and I apologize for the construction on the ground floor. I've already said to the organizers that if they want to leave these chairs here, that's fine. They're very comfy. They add a lot of lightness to this room. Look, I have a very simple message in my presentation today. The message, as you can see from the title, is simply that when we go to talk about balancing of rights and the interests of society, we need to give primacy to the rights. That's the simple point I want to get across today. The last speaker, Mr. Kwok, he used a lot of imagery, so I'm going to also begin with some imagery as well. What does the right balance look like? And I think for most, this kind of image would come into mind, this idea of trying to balance something evenly, rights against the community interests. What I want to suggest is that this is actually not the right image. There's some problems with this image, which I'll explain in a moment. But when it comes to fundamental rights, I'm going to suggest a different type of image. One, of course, as I said, that gives primacy to rights. I'm going to suggest that this image would be better, because what this shows is you start with the rights. That's the big rock at the bottom, and you give that primacy. And also, you notice that there's some water there, suggesting that it's actually very difficult to keep it all balanced like that. So it's not easy to find the right balance, and that you have to actually keep everything balanced for there to be, say, a justified restriction on a right. Right? Whereas if you use the other image, it's very easy, given the interests in society, if it's a serious crime, if it's concerns with victims' rights, protecting the public, convicting the guilty, you put all those together, it's very easy to outbalance the right. And I think there's a danger in thinking of it in this way. The last speaker talked about a narrative. Well, I think also this is possibly a narrative that one has to be careful of, to say that somehow, in almost all cases, the societal interest has to outbalance the fundamental rights. Because this image, the previous one, recognizes a couple of things. The first is that when we talk about rights, especially in Hong Kong, rights are at the constitutional level. So that is the higher law, higher than statute and common law. The other thing it recognizes is that, and this can go back to the history of human rights in World War II, the importance of how rights protect minority interests. It's not about the majority outvoting the minority. Rights are, in fact, they counter that narrative. They protect minority interests. And in fact, some of you may not know, but there's been a very important judgment from our Court of Final Appeal today on same-sex marriage rights in the context of the benefits of a civil servant who was married to his partner, and his marriage had been recognized in New Zealand, and our Court of Final Appeal unanimously has said to deny that person those benefits would violate our basic law. And there's an interesting part of that judgment where there's reference to an argument that we have to give effect to the prevailing interests or sentiments in the community, that somehow that has to be taken into account when we look at justifying rights. And the Court of Final Appeal says, no, those are irrelevant considerations. I want to now just sort of put it in words in terms of what I mean by finding the right balance. So it's really three parts to this analysis. As I said, we start with the primacy of rights. Then I think we also have to take into account the nature of the interests at stake. That is because different rights engage different interests. And also how, in a particular case, that right is engaged could also reflect a degree of interest at stake. Right? So we can talk about serious violations of rights or less serious violations of rights. You have to take into account how the interest is engaged. And then lastly is the point of view of justifying any interferences with rights. And our courts in Hong Kong have developed a very sophisticated approach where we look at these tests of rationality and proportionality and trying to strike a balance in terms of the effects and the means of the law. But as I say, I want to spend most of my time just talking about the primacy of rights. And I'll just give you a few examples from our case law in Hong Kong, which illustrate this basic principle. So our courts have said that there are some rights which you cannot violate. You cannot try to justify. Sorry, let me put it this way. You cannot try to justify a violation because the rights are absolute. Right? So for example, torture, cruel, inhuman, degrading treatment and punishment, and also a fair trial. These are just a few examples. And I think that is all well known in the community. Less well known is a statement in a more recent judgment, Hyson Development from our highest court, had said that there are some violations that are so serious that again you cannot begin to justify them, where the imperial measure has destroyed the essence of the right. And the court gave the example of a case where the law had denied a transsexual woman from marrying. And the court described that as destroying the essence of the right. And you couldn't even begin to justify that restriction. Now I want to focus, particularly given the theme of today's conference, on privacy rights. And I want to illustrate and talk about three very important recent cases, which I think all three of them highlight, firstly, the primacy of rights, and also that framework that I mentioned earlier. Let me just say as an aside, this area of the law is really just developing. I have to say, some of you may tell from my accent, I practiced law in Canada, where they have the Canadian Charter of Rights and Freedoms, which was enacted in 1982. And one of the areas of the law, Jerry McNeely will know this, one of the areas of the law that sort of very quickly saw some significant development was in the area of search and seizure, police search and seizure, privacy rights. a famous case called Hunter and Southern, 1984, from the Supreme Court of Canada, had said that if the police want to search and seize, they basically need a warrant. And that, in fact, reflected the U.S. Constitution approach as well. In fact, when I started teaching here in 2001, the year after, I gave a presentation. We were talking about Article 23 at the time, and I had given a presentation saying that the government's proposal to have a warrantless search power for national security offenses must be unconstitutional. And in fact, the government then withdrew that proposal. But we didn't see any case law immediately afterwards. In fact, it was only around 2016 where we started seeing cases. And basically what the Hong Kong courts are saying is that we need to follow that North American approach. We have to give primacy to the rights and to require what they've described in this judgment, judicial gatekeeping. Right? That when you go to balance in the context of search and seizure, the individual's interests and society's interests, you do that before you search, right? Not afterwards. You don't go and get the materials, search, violate the right, and then try to justify it. Right? You got to do it out before it by getting a warrant. And secondly, they said that any kind of exception to this starting point, this requirement, would have to be certain, ascertainable, proportionate, and have adequate safeguards. Why? Is because the court was very concerned about executive abuse. So the courts were being very realistic, saying that you can't trust, I hope I don't upset the last speaker, we can't think that police are angels, right? We have to take a very realistic approach that they will abuse their powers. And what the basic law and the Bill of Rights requires is that we have safeguards against that. So many of you know that the customs for many years have had very wide powers. I see on the website the customs are celebrating 110 years. And for a good part of those years, that period, they have had powers to search without any warrant, mostly in non-domestic premises, commercial premises. And then this case came along in 2014, 2016, where a court of appeal basically said that that power to search commercial premises without a warrant is unconstitutional. This is quite an important case involving cross-border smuggling, and the police had executed a number of search warrants. But that search warrant power was basically struck down. The second case, which followed on this, is actually quite interesting. It's about searching mobile phones. I think many people probably don't know about this case in this room. Basically, if the police were to arrest you today, and of course, Professor Forsyth showed us the police power in the police force ordinance. Upon arrest, they can search you. They can search your pockets. They can search your bag. They can search your pocket. They can do a pat-down search, etc. But what they cannot do is to take your mobile phone and start to search it. Right? Because of this case. Shan Khan basically says, if you're going to search someone's mobile phone, you need a warrant. And there's two important things I want to highlight about this decision. The first is, it relates to the second point I made earlier in that framework, the importance of the nature of the interest at stake. Because the court noted that the mobile phone is something, and this is probably an obvious point, which we have very high privacy interests, right? Very high privacy interests. And therefore, your safeguards have to be much greater, right? So the court is taking into account that, the seriousness of the stake at risk. Secondly, I would highlight, is there was reference to a Canadian case, Ferrand, Supreme Court of Canada, which had looked at this very issue. And very interestingly, in that case, the majority in Canada said that you can search the phone without a warrant. Right? So the prosecutors were successful in that case. There was a dissenting opinion in Ferrand, and our Hong Kong decision actually follows the dissenting opinion, saying that you need a warrant. I thought that was very remarkable, because we often in Hong Kong think that the Canadians are more progressive in this area, and we're a bit more conservative. But here, the Court of First Instance judge actually followed the the minority opinion, which was the more progressive view in Ferrand. Now, the third case is a very recent case in the context of surveillance. Okay, I'll be very quick. In the context of what we call type 2 surveillance under our law. And type 2 surveillance is the kind of surveillance that doesn't require a warrant. And you can get authorization from a senior officer. This case is quite interesting. It's a bribery case. It involves the CEO of a hotel in Wan Chai, who's been suspected of wanting to take a bribe for issuing a license for a restaurant in the hotel, or authorizing a license. And so the ICAC, which is our anti-corruption body, they undertake an undercover operation. And there are a series of meetings with the defendant in restaurants, with the undercover agents, which are all recorded. Right? And that's a kind of what we call participant surveillance, which would be a type 2 form of surveillance. Type 2 also includes other forms of tracking and camera, but not if it involves trespass or any other sort of intrusive interference. So type 2, by definition, is a less intrusive form of interference. And the question in this case was whether or not this violated the basic law, because it didn't require a court warrant. And the court said that it could be justified. It could be justified. And I think I probably agree with this decision, primarily because of the fact that, again, it's about the interests at stake. You have to also look at what is the nature of the interest at stake. Here, it's a lesser form of intrusion. It's not your mobile phone. It's not about your intimate personal details of one's life, right? If you take that into account, it becomes easier to justify. So I think I more or less accept that. What I don't accept about the judgment is what it said about the proportionality test that you should apply. This has been more technical, but those in Hong Kong will know that we have two proportionality tests for restrictions. One is a stricter one, where we have to say that there's no more than necessary for justifying or for having that restriction. But there's a weaker test where we simply ask, well, is it manifestly without reasonable foundation? And I take issue with the court's use of this weaker test for restriction, because I say it's not really giving rights primacy. There's reference to operational efficiency for having a search without a warrant, if it appears reasonable. But my fear, of course, is it's like thinking about it in these terms, and we simply now add operational efficiency to the balance, and you could easily outbalance the right. Thank you very much.
Okay, we have about 7 or 8 minutes left. About 7 or 8 minutes, so we'll open it up for questions. Thank you to all the speakers for such wisdom. Questions?
Yes, I would like to ask Mr. Cox a question about the... Yes, I would like to ask a question about your use of the notion of policeman as a referee. The fundamental difficulty is this, that a referee does not actually arbitrate between two parties. The referee is there to ensure that both parties apply the rule, and the rule comes from the courts or the statutes, so in no sense are you making a decision between two parties, although in a sense you might be saying, well, yes, you're right because you were attacked, you have a right to defend yourself, so you might be... But all that is merely an application of the law. And since we all agree that the police are obliged to apply the law, no question of abusing any civil right can arise. It can only arise where the police officer is not applying the law, and I think we all agree that police officers cannot do that. So, if I may say so, I find your criticism of the title of the symposium somewhat baffling.
Thank you, Mr. McNeely. Adams. Well, first of all, I don't think we disagree, okay? I think, but I have to suspect that you have never been in a street fight. The reason I say that, okay, I think, you know, my analogy of police officers being a referee is entirely accurate, okay? The reason I say that is, okay, we are not there to arbitrate, you know, what is right or what is wrong. If you ask any police officer, okay, how does he conduct his business on the street? He looks at, well, he's been taught the law book and told what the rules are. And then he goes to a situation and says, okay, the rule book says, okay, he's in the wrong, he might be in the wrong, he's definitely in the right, and, okay, and then he decides his action accordingly. The problem is, okay, most people will say that they are in the right, but the other party is in the wrong. So what we arbitrate is that interpretation of the rule. And this is a daily occurrence. And that is the difficulty of being the police officer, because we are the only person, okay, in this whole chain of events, okay, who have to deal with the reality. This is not a slight on the job of lawyers and judges, okay, in court. But the fact is, okay, you cannot escape the realization that in court you're dealing with the sanitized version of the facts. You are relying on the written record of what he said and what she said. Police officers on the street have to deal with the reality in real time. And if he doesn't do a good job, there is immediate repercussion. People may die. All right? So I hope, okay, that is a bit of a look at the reality of the difficulty that gives some background to my analogy there. But I also would like this opportunity to just say something, okay. Professor Young, okay, earlier made a very eloquent dissection, okay, of some case examples and some principles. I completely agree with those things, okay, because as a police officer, I think I speak on behalf of those colleagues who are here. We do not make the laws, okay, legislators make the law. Legislators make the laws on behalf of the citizen, and we are just part of that group. We take the law book and then we are told to do certain things. So those, you know, primacy of rights, okay, we do not have a disagreement with that. But what I can offer, okay, this audience and, you know, the public in general is that when we say we want some safeguards for certain rules, certain rights, okay, know that we always pay a price. So to actually discuss safeguards, okay, without regard to the price that we're paying, okay, I think is irresponsible. But when do you actually hear about the discussion of rights ever spoken in the same, you know, in the same sentence, okay, any reference to what kind of price the society is paying? For example, if you give primacy to a certain right, okay, you know, these, you know, the threshold to be reached, okay, before you can search a mobile phone, for example, okay, just know that this safeguards privacy of certain individuals, law-abiding citizens, but at the same time, okay, it is also a barrier behind which criminals can hide. And that's something that is rarely mentioned. And I think it's a very important one.
Okay, great. Thank you. Let's move on to, because I'm getting the signal. So we have time for maybe one or two more questions.
Thank you, Karen. I just wanted to just raise one point. Thank you. I think both Justice Adams and I think Simon, as well as, in fact, Christopher, Oscar, they all made very similar points in my view. I think if you look at public order events around the world, I mean, you look at, for example, one event that I see Mr. Trump actually talked about white supremacists as being, you know, somebody that should prevail. There's very decent people. And during that situation, you have white supremacists, in fact, fighting, in fact, very liberal people. And the police is always sort of in between that. in essence, with both sides having very trenchant views. And you sit in between, trying to give everybody their rights, essentially, the rights of free expression, but at the same time, the duty to ensure that you don't harm anybody else. So that's what I call the referee in this situation. And indeed, rights should have primacy. And the question would be, because they are never absolute, the question, therefore, it has to be modified by the duty that people, that each owe to each other as a member of the community. I think it might be helpful in due course that because you have communities that have issues like that, a lot of history. For example, the United Kingdom, the Home Office has produced, in fact, a code of practice for public order authorized professional conduct, for example, where in fact the developing law is codified into a set of principles where police officers throughout the United Kingdom, from Scotland to Northern Ireland and so on, should abide by as a code of conduct. That, of course, encapsulates the law, but also some of the operational principles that police officers do. And that's something that perhaps Hong Kong might in due course aspire to. And I hope perhaps, you know, I've spoken to the Commissioner, to Oscar, and to Edwina, and this is something that we could probably do in Hong Kong. Thank you.
Okay, one last question? Anyone? Okay, I think we need to move on to the next stage of the symposium. So, but first, could we welcome all the speakers and their wisdom?
Thank you for sharing your views to us. Please stay on the stage. May we now invite IPCC Chairman Dr. Anthony Neo to present his souvenirs to our guest speakers. Okay, we start with Professor Laidler, please. Professor Forsyth.
Thank you again. Thank you very much. Thank you. I think we need to get photographed. Thank you. Thank you.
Mr. Kwok, please.
Okay. Oscar, thank you very much. Thank you. Thank you.
And the last one, Professor Yang.
Thanks again. Thanks for it.
Will all the guests on the stage take a group photo together? Thank you, everyone, and please take a seat off the stage. Before we proceed to the third plenary session, let's have a 10-minute break on the first floor. Please enjoy yourself and be back on 3:45.